Good evening, students. Today we are going to discuss a latest case in relation to the freedom of profession, of trade, and how can the right to shut down your business come within this umbrella or set of rights or freedoms that we enjoy. Now, rather than starting with the facts of this case, I prefer we discuss the concept that is involved when we talk about the right to shut down your business, and then we will move on to discussing what actually happened in this case and how the court went about deciding on the matter. Right. So, when we talk about the freedom to speech and the freedoms that are enjoyed under Article 19, it is basically in relation to your freedom of trade, profession, etc. And what has to be borne in mind is that when it comes to the fact that if you enjoy your freedom of speech, if you enjoy your freedom of trade, then the inherent part of freedom of starting a trade or starting a business is that you must be able to then enjoy decisions of closing the business. So one can say that there is an access that is available to an individual to this particular freedom, which is that to shut down your particular uh, business. And therefore what has to be taken into consideration is the fact that if you are having a business, then constitutionally this freedom may percolate to the right to shutting it down. Give me a moment, students. I'll just try to share the screen. All right. So we have 191G, which gives us this freedom. And additionally, when we look at this umbrella, it also gives us the right to shut down the business. But can we say that these two rights, that is the right to start a business and the right to shut a business, are on the same footing? Maybe not. Now, in this case, there is a reference to a landmark decision where it is accepted that you do have a right to start a business and therefore you will always also have the right to shut the business, but they are not on the same footing. The right to shut down a business can be a little tricky. Now, as we know, because we do have freedoms, these freedoms also come with some forms of restrictions, right? And these restrictions can be introduced if they are in the interest of general public. So you do have a right to trade, you do have a right to start a business, but if that business is not in the interest of public, or for example matters like where alcohol or noxious substances are involved, these business can have restrictions because the rights of the public have to be protected, and that can lead to a restriction on your freedom. In the same way, if you have a freedom to shut a business, if your shutting of the business is going to affect the public or a community or a class of people, then maybe some restrictions can be put on that, right? So this is a very interesting discussion which comes forward, that if you start a business, that's a freedom, but it can have restrictions if those are in the interest of general public. Same way you can shut down your business, which is a right coming out of your freedom to start a business, but there may be restrictions on shutting down if they are going to affect general public. Okay. Now, taking this conversation forward, we now look at the Industrial Disputes Act, which is a part of this case. The Industrial Disputes Act was made for what reason? It was to protect the interests of labor, of workmen. So the objective is to protect their rights, the objective is to safeguard them, right? And to avoid their exploitation. So whatever provisions are made, they are most often with the intention of protecting their interests. So in context of, or in the idea of, if you have a business, you start a business, that's a freedom. You may employ, like, let us say 500 people for this business. When you decide to shut down, which is a right you enjoy, your shutting down of this business may affect the life of 500 people. So your freedom is affecting public, and therefore a restriction can be put by the state because it is going to affect lives, right? And that's where this act comes into picture, because it makes provisions, it makes sections which may be with the aim of protecting the right of these workmen when you shut down your business. So we are trying to understand in this situation that there has to be a balance between safeguarding your freedom and also to ensure that the people that you have employed do not suffer because of the decision you made. Since this comes under the umbrella of the interest of public, this act, that is the Industrial Dispute Act, thus does contain some provisions which may clearly point out to the fact that they are safeguarding the interests of workmen. Now, in this case also, one such section has been discussed. Okay, this is section 25O. This is in relation to the closing down of a business. If you have to close down a business, what are you supposed to do? You have to make an application to the appropriate authority, right? And you will have to give reasons, compelling reasons why you need to close down this particular business. The government, after making its inquiry, etc., giving an opportunity to be heard to all the stakeholders, will then take a decision as to whether they should accept this application of closure or whether they should reject it, right? So this order which is passed by the government must be justified. So they have to give reasons why they are accepting the application, or why they are rejecting this particular application. So application made by the business owner to close his business, inquiry will be made by the appropriate government, and then they will pass an order deciding whether it is to accept or reject that particular closing of business and provide reasons for the same, right? Now there is another aspect to this particular section. It says that if this authority doesn't deal with your application in 60 days, it is deemed that your application has been accepted. So there is a presumption which comes into picture if no decision is taken within 60 days by the appropriate government. Now, what do we understand from 25, from this particular section? We understand that you have a right to close your business, but the government will decide based on the reasons you give. And why are you supposed to give these reasons? Because your closure of business will affect other employees. That's why your this freedom is being tested, because you need to justify whether or not it is actually required or feasible to close this business and how it might impact other people. The government will assess this and then decide on the matter whether you can or cannot close the business. But this deeming fiction, which is created in this third subsection, states that in case you the government does not fulfill or respond or complete their decision within 60 days, it will be presumed that you have been granted permission or the order has been passed in your favor and you can shut down the business. So this does have tonalities of creating a restriction on your freedom to shut down the business, but it is in the nature of, or in with the objective of protecting the interests of the employees or the workmen, right? So that tonality of reasonable restrictions for general public is there. In this case, the Orista textile case has been referred to, and it highlights the fact that section 25 recognizes the circumstances wherein no compulsion to continue or to run the business can be established. So it provides the situations wherein, or it highlights through its language when you are expected to run the business and when you can give reasons why you cannot run the business. It has that tonality. Okay, now we come to our case. Our case is in relation to HSML, which is an enterprise which was manufacturing biscuits. These biscuits were for Britannia and they were in a job for work agreement on the basis of which SML only produced or manufactured biscuits for Britannia, no other company. And therefore, what happened is when Britannia terminated this particular job for work agreement, then this company had no work. The machinery, the everything required for the making of the biscuits, etc., was provided by Britannia. Now, once this agreement was terminated, HSML basically had no work. HSML therefore decided, as per the requirements of Section 25, to make an application to the appropriate government. Now, this particular application was responded to by the government on 25th September. What has to be noted is that in the application which HSML provided, they gave reasons that we were only catering to Britannia. Now we have no work. We didn't even have any manufacturing machinery also. That was also given to us by Britannia, and therefore now there is no purpose for us to function, and therefore we want to shut down. So those reasons were given by HSML, and the government responded saying this is not sufficient reason. You have to give more relevant reasons to shut down the business because you have a large number of workmen with you. To this, now again, HSML responds and says that, sir, we have tried to find other companies. We have approached other companies like ITC and Parle, but they don't need any manufacturing facilities or services. And therefore, we are not finding any other alternative place to continue our business. This response HSML gave. Now, by 27th October, 60 days had passed, which meant that the deeming fiction aspect has come into picture. HSML says now since 60 days have passed, it means, and since no order has come from the appropriate government, we can consider that the application is accepted and the business can be considered to be allowed to be shut down. Right? Now, contrarily, the government says that we had passed an order on this date only because in our application, in what we had submitted, we had said that you have not provided sufficient reasons, etc., and therefore we cannot accept your application and so on. So they are trying to say that this particular response was in the idea of an order. Whatever they responded with was actually their rejection of the application. This led to two questions. One question: since the letter was responded to by the deputy secretary, can he be considered the appropriate government, which is a requirement of Section 25? The court answered in the negative. He cannot be. The appropriate government will always be the Minister for Labor. He, in this case, has been notified as the appropriate government. So, the only person who can be considered as the appropriate government is the person who has been notified to that extent or to that in relation to that particular phraseology. Whereas deputy secretary, there is no such specific notification of delegation that has come in. So anything coming from him is not relevant. It has to come from the minister. Right. Now, another argument that was put forward is that there was some kind of endorsement from the minister. on the file. And therefore, this argument was put forward that since the minister has endorsed the file, this particular whatever response has come, response has come from the minister, and this should be considered the order of rejection of application. The court answered with saying that an order, as we have discussed in the past, is not something which is very to be taken lightly. This order passed by the appropriate government must have reasons of why they are accepting or rejecting the application. So it requires an application of mind from this particular appropriate government, and that must reflect in the administrative order passed by them, through the order, through the reasons given by them. Just a letter responding saying that you have not provided sufficient reasons does not is not equivalent to the order that is required, right? And secondly, this was a file which was coming from some officer of a lower cadre, and then it went up to the minister, and minister has simply said, yes, this is right, this is okay, we must ask for more reasons. What an order requires is that it must come from the minister, that is from top to down. It is the minister who will give the decision after applying his mind and providing reasons in the order, and then only will it be considered a legitimate rejection of application, a legitimate administrative order rejecting the application. In this case, a simple endorsement by the minister cannot be equated to the same thing, endorsing a file which came from the lower officers towards him. I hope you have understood this aspect, students. Repeating myself in this particular half of the case. First thing, deputy secretary cannot play the role of minister for labor. So anything coming from him cannot be considered appropriate government. It is the minister for labor who has to be the person who is initiating or responding to the application in the context especially of the order, whether accepting or rejecting the application. Second thing to remember, it must have reasons and it must reflect that there is an application of mind from the appropriate government. An endorsement coming from the minister is not the same thing, right? Now, that's the reason why the court accepted the fact that after the completion of 60 days, there was a deemed closure on the, and therefore HSML was in the right footing to close down its business in this particular case. The court did increase the amount of compensation that they had to give to the workmen, but they did agree that subsection 3 of section 25 comes into picture in this case, and a deeming fiction comes into picture where the application for closure has been accepted. So I hope you have understood this interesting aspect, students, of the fact that your right to start a business inherently does also include the right to shut a business. But because there is the aspect of reasonable restrictions, there can be situations where you cannot very easily shut your business, and the government may interfere, like in section 25, intervene and question and expect you to provide reasons for shutting down the business, just as they did in this particular case. Thank you, students. I hope you liked this video. In case you like it, please comment, or if you have any queries, please comment and like the video. Thank you, students.